Morning, let's give it just a minute. It's still coming on here. Good morning, ladies and gentlemen. Welcome to the 10th Court of Appeals. Oral argument being held in Waco, June 15, 2022. And I do that specifically today because this is being live streamed on YouTube. And so it will be recorded there. I won't go through the history of how we got here. Part of it is pandemic, but part of it relates to just pre-pandemic. We were doing the audios, but now that we have this feature, we do the video as well as the audio.
I don't think the video is
There it is. Thank you, Matt. Sometimes it's hard for me to tell if it is or not. So I know I don't need that. I won't be getting any phone calls. I hope y'all don't get any phone calls. I hope you put your phones in the off or silent position. And if anyone has a pager, I'd like to see it because those are kind of antiquated these days, but they used to be a problem. We've got one case on the docket today. It is in the interest of Justin G. Dart, docket number 1021-00142 CV. And if there are any exhibits or anything, any preliminary matters that we need to take up, I'd like to do that at the time of the announcements. And if I could have announcements of ready and whether or not there are any issues from the parties.
Yes, thank you, Megan Whitehead, on behalf of Appellant Katrina Ahrens as independent executor of the estate of Lauren Ahrens deceased. I'm joined today by Grayson Daniel, and Appellant does not have any exhibits or other items. We are ready.
Okay, thank you, counsel.
Thank you, Your Honors. Kevin Spencer, Blake Spencer, and we represent Justin Dart, and we do not have any preliminary matters either.
Okay. Question on splitting time. Are you going to be doing all arguments, Counselor Whitehead, on your side?
Yes.
And it's going to be a little confusing if I say Counselor Spencer over here. So you're Blake.
I'm Kevin
You're
Spencer.
Kevin.
I'm sorry, I wasn't clear about that. This is Blake Spencer.
And Kevin, are you going to be doing all the argument on behalf of Mr. Dart?
Yes, Your Honor.
Okay, thank you, Counsel. You may proceed to the lectern when ready. Counsel, anything else? Our colleagues, gentlemen, judges? Okay.
One thing I wanted to just ask if they're going to be rebuttal time.
Yeah, there's it's 20, 20, and 5 minutes rebuttal. And if you don't use all your 20 minutes, it doesn't get added to your 5. And we always appreciate the time back if we don't use it all, but don't feel like you have to use all of your time. But the 5 minutes is a solid 5 minutes, doesn't change.
Thank you, Your Honor.
You may proceed when ready.
May it please the court. Jurisdiction is always the first question in any case. And here, the trial court did not have jurisdiction to enter the judgment at issue. Appellate Katrina Ahrens, as independent executor of the estate of Lauren Ahrens deceased, asked this court to vacate that judgment because a lawsuit to adjudicate paternity cannot be brought after the death of the putative father. No facts relevant to this appeal are in dispute. First, Lauren Ahrens was killed in the line of duty almost 6 years ago on July 7, 2016, during the sniper attack in Dallas. And second, Dart filed the underlying lawsuit in this matter on September 22nd, 2020, over 4 years after Lauren Ahrens was killed. A few critical points before digging further into the statutes specifically at issue. Dart asked the trial court to adjudicate he is a biological child of Lauren Ahrens. The Texas Uniform Parentage Act, in particular Texas Family Code section 160.103A, explicitly provides this chapter, chapter 160, governs every determination of parentage in this state. As a result, any such adjudication of paternity, such as the one made by the underlying trial court, must be made following the procedures laid out in chapter 160 of the Texas Family Code. The adjudication of paternity that Dart seeks is a serious matter, and Dart must meet all the requirements of Texas law, which includes joining the necessary parties and ensuring that the trial court had personal jurisdiction. Because Dart cannot do so, namely because Lauren Ahrens was killed 4 years before Dart filed his lawsuit, his claim fails, and the judgment should be vacated. Turning to the specific statutory authority The relevant statutes are clear on their face. The Texas Family Code Section 160.603, entitled Necessary Parties to Proceeding, states, the following individuals must be joined as parties in a proceeding to adjudicate parentage. 1, the mother of the child, and 2, a man whose paternity of the child is to be adjudicated. It's undisputed that Lauren Ahrens was not a properly joined party to the underlying lawsuit, as he was killed 4 years before the lawsuit was filed. Additionally, Texas Family Code Section 160.604A states, an individual may not be adjudicated to be a parent unless the court has personal jurisdiction over the individual. The trial court does not have jurisdiction over a deceased person. Thus, because the trial court never had personal jurisdiction over Lauren Ahrens, who died before Dart's lawsuit was filed, the trial court lacked jurisdiction to adjudicate Lauren Ahrens to be the biological father of Dart. Because Dart does not and cannot meet these jurisdictional requirements of Texas Family Code, Chapter 160, the judgment must be vacated. Case law analyzing the specific statutes at issue underscores the trial court did not have jurisdiction to enter the judgment. The Houston Court of Appeals in Frazier versus Hall, 2012 Westlaw 215-9271 at page 2, states, the Uniform Parentage Act provides that the necessary parties in a proceeding to adjudicate parentage are the mother of the child and the man whose paternity of the child is to be adjudicated. The act mandates that an individual may not be adjudicated a parent unless the court has personal jurisdiction over the individual. There, the Houston Court of Appeals cited to Texas Family Code Sections 160.603 and 160.604 and declined to exercise jurisdiction because the mother lived in California. We ask that this court follow the Houston Court of Appeals and find that similarly the trial court lacked jurisdiction because Lauren Ahrens was deceased 4 years before the lawsuit was filed. Thus, the trial court did not have personal jurisdiction over him. Similarly, the U.S. District Court for the Western District of North Carolina in Schaefer for WMS versus Estrue, and it's 2009 Westlaw 106-81207, considered these exact statutes and came to the same conclusion proffered by appellant. That court found in the present case, the Texas District Court did not have jurisdiction over all the persons governed by the judgment. The Texas Family Code states that the necessary parties to a proceeding on paternity are the mother of the child and the man whose paternity of the child is to be adjudicated. While the wage earner was a necessary party, he was deceased at the time of the paternity proceeding and not a party to the action. The code goes on to state that an individual may not be adjudicated to be a parent unless the court has personal jurisdiction over the individual. The court did not have personal jurisdiction over the wage earner since he was deceased at the time of the proceedings to establish paternity. In the briefing, Dart attempts to factually distinguish Schaefer, but does not address that the federal court there considered the exact two statutes that we are discussing here today, 160.603 and 160.604, and came to the exact conclusion proffered by appellant that the trial court did not have jurisdiction to enter the judgment for paternity. Even more recently, in 2021, the Austin Court of Appeals in City of Austin versus Membrano Lopez as next friend of Lopez, and that's 632 Southwest 3rd 200, stated at footnote 19, we note that Chapter 160, Subchapter G, does not appear to contemplate a posthumous proceeding to adjudicate parentage. And there, the Austin Court of Appeals cited Texas Family Code Section 160.603, establishing that a man whose paternity of child is to be adjudicated is a necessary party to proceeding. So in response to these explicit cases that construe the exact statutes at issue in this lawsuit, Dart's response is that the plain language and Dart's response to the plain language is that instead he can sue Katrina Ahrens as executor of Lauren Ahrens' estate instead of Lauren Ahrens deceased. And that's wrong, Your Honors, for at least 4 reasons.
Before you get to that argument about the capacity of the independent executor and their position, they've also argued about 160.604C, that the lack of one jurisdiction over one. How do you respond to that argument?
Turn to that exact language. Your Honor, I respond to that in that C and A can't contradict one another. They have to be read in a way that doesn't make either provision superfluous. And A explicitly provides an individual may not be adjudicated to be a parent unless the court has personal jurisdiction over the individual, meaning born errands may not be adjudicated to be a parent unless the court has personal jurisdiction over born errands. Then that is clear under A. Looking at C, that does not create an exemption for a necessary party, for the man whose paternity is to be adjudicated. Instead, that creates, for example, if the couple had a child, another child, and that person wasn't a party to the lawsuit and the court didn't have jurisdiction over them. For example, in this instance, if Justin Dart had a sibling that lived in another state, this court would, or the trial court would not have personal jurisdiction over that individual. And so that wouldn't create an exemption such that the trial court couldn't enter an adjudication.
Well, counsel, let me ask you this. Mr. Dart was a minor under our law at the time his father died, correct?
Yes, Your Honor.
How do you respond to the appellee's contention that his rights to establish paternity can't be forfeited by the fact that either his father nor his mother took any action to legitimate him before his father's death, when he could not himself?
So I think it really boils down to the plain language in the statute. And under 160.103A, it's very clear that the only way to adjudicate paternity in Texas is following the code provisions in Chapter 160. While I recognize that at the time Lauren Ahrens was killed, Justin Dart was a minor, he could have reached out in other ways to establish a relationship. I mean, while yes, he has the right to bring a paternity suit, the Supreme Court has made clear that those rights are limited and that there are exceptions to those. And that's one of the cases here. If I can.
While you're looking at that, does that fly in the face of apparently the announced public policy position of we don't want illegitimate kids?
It doesn't. So case law recognizes, yes, that a child born out of wedlock has the right to bring a paternity suit. However, that right has limits and they've not been infringed upon here. And specifically, the U.S. Supreme Court has made clear that a state has the ability to restrict the rights of those born out of wedlock if the means used are substantially related to a legitimate purpose. And that very critically in Lawley versus Lawley, and that's 439 U.S. 259, the U.S. Supreme Court upheld a New York statute that allowed a child born out of wedlock to inherit from his alleged father only if the question of parentage was resolved during the father's lifetime. And I think that decision really illuminates on your question, Justice Smith, because it talks about the state's substantial interest in mitigating serious difficulties in the administration of estates. And it also talks about the importance of also requiring the putative father to be a party to the lawsuit so that he can tell his side of the story and so that his rights are represented in the lawsuit. If we take a step back, I think we really think about what the purpose of the adjudication of parentage is. It's to establish a parent-child relationship. And with that goes all of the duties, rights, and responsibilities of a parent-child relationship. Arguably, the most important duties, rights, and powers that exist. Those include the duty of shelter, the duty of support, the duty of care, all of which makes sense that the Texas legislature would expect and require a putative father to be a party before a court assigns all of those duties, rights, and powers to him. And that's why he's a necessary party to the proceeding. and why the court has to have personal jurisdiction over him. And that's also why it doesn't make sense for Justin Dart to be able to sue the executor. The executor isn't stepping into the shoes of the putative father. This isn't, a claim for debt. This is to establish a parent-child relationship. Justin Dart does not seek to form a parent-child relationship with Katrina Ahrens as the executor of Lauren Ahrens' estate.
And before you go fully off into the executor distinction, because I know you've got 4 points to get there, in connection with the inheritance, there is an entirely, so that I understand, there's an entirely different procedure to establish heirship that the parentage relationship doesn't necessarily control.
That's exactly right, Your Honor. I think that's a very important distinction to make, that this isn't about inheritance. What he asked for from the trial court was an adjudication of parentage under Chapter 160 of the Family Code. And what that does is create a parent-child relationship. And what he's seeking is to be declared the biological child of Lauren Ahrens. And had Lauren Ahrens been alive, that would have created a parent-child relationship between them. And at that point, Lauren Ahrens would have all the duties, rights, and responsibilities that a parent has under Texas law. And some of those include, as this court is familiar, the duty of care, the duty of support, the duty to shelter, the duty to provide clothing. In fact, the number one reason that this procedure is used is in order for a biological parent, a putative father, to be found the father such that then there is a support obligation. That terminates at the death of the putative father as well. And so, again, stepping back, thinking logically about this relationship, it doesn't make sense for Justin Dart to seek a finding of paternity, a parent-child relationship with the executor of Lauren Ahrens' estate. Because what that adjudication does is create a parent-child relationship under Chapter 160. But none of those duties, powers, or rights transfer to the estate. They all cease upon termination of Lauren Ahrens being alive. They ceased July 7, 2016. And so it just doesn't make sense that the executor could stand in the shoes of a deceased putative father. Also, from a Texas legislature intent standpoint, the reason 160.603 and 160.604 exist, requiring the father to be a party and requiring the court to have personal jurisdiction over the alleged father, is to give him an opportunity to tell his side of the story before all of the rights, duties, and obligations of fatherhood are assigned to him by a court of law. That's critical. And the trial court did not have jurisdiction over him, and he didn't have an opportunity to tell his side of the story.
Well, in the context of his side of the story, how is that affected by the fact of the 2001 Act and the technology that we have today of DNA?
I think that's a question for the Texas legislature, Your Honor. At this point, our code was enacted in 2001. The language is plain. To the extent it does provide for genetic testing, but as we stand here, or as I stand here today, the law is what it is, and we have to apply it as written. It's not ambiguous. No one has argued that. And so we have to interpret and rely on the plain meaning. To the extent that technology has changed, the Texas Supreme Court in Lee versus City of Houston, 807 Southwest 2nd at 293, has instructed our function is not to question the wisdom of the statute, rather we must apply it as written. And as it is written today, whether it was enacted in 2001 or 1909, we have to apply it as written. And today, our law by the Texas legislature requires that the putative father is a necessary party to the lawsuit, and the trial court has to have personal jurisdiction over him.
You had 4 reasons on your executor argument. Did you work all of those in?
I'll give them to you at a high level, Your Honor. simply saying that there is not any explicit provision in the code that allows the executor to be joined as a necessary party in lieu of the father. That's not in 160.603. That's not in 160.604. I think any of the cases relied on in the briefing we've distinguished, but really thinking about the purpose of this act. One case I do want to draw your attention to is In Interest of George, 794 Southwest 2nd, 875. And it did consider a prior version that's been repealed and replaced by our current version, but the reasoning there is still applicable to the current version that we're looking at. There, it discusses that the family code does not contain an explicit provision for the survival of the action after the alleged father's death. Our family code still does not. The paternity is a creature of statute, and when statute fails to expressly provide for survival after death, it does not survive. That applies with special force here, given that after the Interest of George case was decided is when the legislature input the explicit necessary party and personal jurisdiction requirements into the Texas Family Code. One provision that DART will point to is the venue provision, and that's Texas Family Code section 160.605. And there's an important distinction I want to draw there. It says venue for a proceeding to adjudicate parentage is in the county of the state in which 1, the child resides or is found, 2, the respondent resides or is found if the child does not reside in the state, or 3, a proceeding for probate or administration of the presumed or alleged father's estate has been commenced. So as this court knows, of course, venue and jurisdiction are different, and for proper adjudication to, for proper judgment to be in place, both venue and jurisdiction have to be satisfied, and they're not here. Personal jurisdiction is not, and necessary parties were not joined. That being said, there is a way to read all three, 603, 604, and 605, such that they all make sense together. And that is if, when the suit is filed, the putative father is alive, he's joined as a necessary party, the court has personal jurisdiction over him, personal jurisdiction attaches. As we know, sometimes litigation can take a little bit. If he dies sometime during the proceeding, then had it been brought where the child resides or is found, it can be transferred and venue can remain and is in a county where the probate has been commenced. That's one way that we can read this act as the canons of construction require, such that all three provisions can be satisfied. There are no further questions. I will wait until rebuttal.
Thank you, Counselor. You'll have 5 minutes for a vote. Counselor, you may proceed when ready.
Thank you, Your Honor. May it please the court. Most of what you've heard and most of the position of appellant is related to old law, really UPA, pre-UPA law that I'll address in just a minute. But I want to make sure your honors are certainly clear from the briefing, and my colleague just said, there's no dispute as to the facts here. Justin Dart is the child of Lauren Ahrens, Officer Lauren Ahrens, and the judgment made clear that even without the parentage, the DNA testing results, there was enough evidence to prove that Lauren Ahrens was the father. So there's no dispute that there's a parent-child relationship here. The dispute is over whether the parentage case can be brought post-death under the UPA, the current UPA. And I really think, based on Blake Spencer, my associate, in our review of the cases, we think this is a case of first impression relating to that particular loan issue. Can you bring a parentage case after death. There are cases that talk about that, but the cases that have been cited throughout are primarily pre-UPA cases. And really what appellant is asking this court to do is to send us back to the dark ages where kids were called bastard children and illegitimate children born out of wedlock are treated differently than those that are born within wedlock. And it's clear that the Equal Protection Clause of the 14th Amendment does not allow for children to be treated differently for all
Are
purposes.
you arguing the statute is unconstitutional if that's what it said?
I'm arguing that I'm not arguing the UPA is constitutional because I believe that it's in congruence with the 14th Amendment and equal protection. And so,
Well, I have to pursue that if their argument is accepted by the court. Are you arguing that it is unconstitutional?
yes, I believe the appellant's position is unconstitutional. And if the court agrees with that, I believe that would be a finding that the UPA is unconstitutional because their position is that Justin Dart, solely because he was born outside of wedlock, should be treated differently than Katrina Ahrens, who's the executor of Warren's estate. Her kids who were born within a marriage of Lauren and Katrina Ahrens. And so they get treated one way.
Has the Attorney General been notified that we're arguing about the constitutionality of the statute?
No, Your Honor. But in the two statutes that you've heard, 16603 and 160.604A are the two statutes that the appellant bases their whole argument on. They're not fighting over the facts. They're fighting over whether this can be brought. And they're basing it on the concept that a dead person cannot be served. And that, if that alone would eliminate claims for parentage, it would eliminate claims for all sorts of things, such as creditors' claims, contract claims against an estate, et cetera, because the dead person wouldn't be able to be served. And we all know that executors, independent executors, administrators are appointed and stand in the shoes of the dead person for purposes of claims based upon conduct that the decedent's conduct that gave rise to the claim. And that may be properly brought and cited in our case, Rick B. Jensen, that may be proper in our brief, that may be properly brought against the personal representative of the estate or beneficiaries or heirs. And so their claim is that, well, we can't serve the dead person, the dead father, therefore there's no jurisdiction can be acquired. But the personal representative, who in this case, and the judgment made clear in this case, Judge Hewlett made clear that the independent executor of Warren Ahrens estate was duly and properly served, and she was before the court, and she appeared at the trial, and they presented no controverting evidence of the parentage.
Counsel, let's just take it straight on. How do you deal with 16604A that says an individual may not be adjudicated to be a parent unless the court has personal jurisdiction over the individual?
Well, I think the legislature addressed that in 160.604C, and I think Justice Gray, you may have brought this up earlier, that the lack of jurisdiction over one person, the dead person, does not prevent an adjudication of, and it says specifically, making an adjudication of parentage binding on another individual over whom the court has personal jurisdiction. So Melody Dart, the mother, was before the court. She appeared at the hearing and signed a waiver of service, so there's no issue with that. The independent executor of Lauren Ahrens estate was duly and properly served and appeared at trial. And so parentage adjudication can be found and made binding upon the mother, Melody Dart, and Lauren Ahrens' estate. And that would then provide Justin Dart all the privileges that goes along with the finding of being a child of Lauren Ahrens. So I think that statute eliminates the need to personally serve the decedent who would be in the grave by allowing his the personal representative of his estate to be served in his place. And that's who, if he were alive, it would be against him. Now that he's dead, it's against his estate and would be binding upon any interested person in his estate. In addition, Ms. Whitehead mentioned it, but I think the the venue statute indicates that the legislature intended that that a parentage action can be brought post-death. A venue for a proceeding to adjudicate parentage is in a county of the state in which a proceeding for probate or administration of the presumed or alleged father's estate has been commenced. That venue statute alone contemplates a case being brought, but then we look at section 160.610, which is joinder of proceedings. And it says that except as provided in subsection B, a proceeding to adjudicate parentage may be joined with a proceeding for adoption, termination, et cetera, or probate or administration of an estate. And so that we believe is specific. It's a specific site to the legislature expecting that the parentage claims be associated with and fall within related to jurisdiction. It would be a probate proceeding under the estates code and are related to jurisdiction
Maybe I'm not understanding your argument correctly, but under section 166.10 joinder of proceedings,
Yes,
you just read A, but subsection B says a respondent may not join a proceeding described by subsection A with a proceeding to adjudicate parentage.
with a proceeding to adjudicate parentage brought under chapter 159, Your Honor. And so we think that's a different, B doesn't apply in this case because of that tack on. Determining parentage obviously does affect the administration, and it would fall into the category of a probate proceeding and a related to probate proceeding, which gives jurisdiction to the probate court to hear those matters. In addition, I want to address 160.603. I think I've mentioned it because if the claim is something that's caused by the decedent, the claim arose as a result of the conduct of the decedent, then the personal representative or heirs and beneficiaries can be served and sued in his stead. The other thing that's important is the purpose of the
Let me kind of follow that out just a little bit. You said if it's caused by the decedent and it's claimed by someone else against the decedent, is there something that you can point us to that is different, as the appellant has pointed out, the difference between creating a relationship and creating a debt is probably a significant difference. What is it about creating a relationship of parent-child that would bring it under the estates code like a debt?
Well, it certainly would go to the assimilation settlement of an estate if the child has an interest in the estate. In this case, that's not.
Do you disagree that anyone can position themselves under the estate code as an heir of a decedent?
Yeah, under the inheritance statute. And one thing to note there is that particular statute, Estates Code 204.051, cites back to, and this statute is the statute that allows the court to order someone to submit to DNA testing.
Mm-hmm.
And that's to submit to DNA testing as provided by subchapter F, chapter 160 of the Family Code. But to your point, Justice Gray, yes, the inheritance is sort of a different animal. In this case, Warren Aaron's had a will and it passed everything, all of his property to his spouse. And so Justin is not trying to establish his relationship to deal with that. It's too late to contest that will anyway. What he is, the relationships that I want to address that you brought up are myriad. One is that there are familial relationships with grandparents as well through Warren Aaron's. And so that's been established by Justin and on a personal level, but from a legal standpoint,
he's entitled to have a parentage determination for that purpose, but also for all the benefits that come from being the child of a fallen officer. And we've cited in our brief numerous ones, but in this case, one of the benefits that came up was the Assist the Officer Foundation, who has collected money based upon the 5 officers that were killed by the sniper, and intends to distribute money to the spouse and the children of those fallen officers. Justin, if he's found to be, and he has been found to be a child pending the outcome of these appeals, he would be entitled to that benefit. But he's also entitled to government benefits related to survivorship, healthcare coverage, tuition forgiveness, payments for children of the deaths of parents who died in the line of duty. He's entitled to change his birth certificate, find out knowledge about his medical history, and there are also other federal benefits as well. And so there's lots of reasons, that property reasons, personal reasons, that based upon the relationship. It has nothing to do with creating a relationship with Katrina Ahrens. They never even talked to each other, Justin Dart and her. It has to do with all of the benefits and the relationships that flow from Justin Dart being found to be the child of Warren Ahrens. And so, and that is, to answer your question, that is different than inheritance. Inheritance is, and he would technically be an heir of the decedent, but the will would obviously trump that from an inheritance standpoint. And so there are lots of reasons why that this is important to Justin, and would be for any illegitimate child. In addition, the UPA, the former statute to the UPA, Chapter 13, which is cited throughout the George case, which the appellants rely so heavily on, predated the UPA. And the George case, I think, was backward looking. The Manuel v. Spector case was forward looking and recognized the need to protect illegitimate children. And the ASL case, and all these cases are pre-UPA, but the ASL case that's been cited dealt with the George case and the Manuel v. Spector case, and decided that the Manuel v. Spector case was better reasoned and was more in line with equal protection and protecting illegitimate children, treating them the same as legitimate children. And so the chapter 13 had to do with, and you've heard, and the George case relates in its footnote about 11 or 12, a large number of rights that would flow through the parent-child relationship, but they focus upon the parents' rights in relation to the parent-child relationship. The UPA and when we cited in our brief, the purpose of the UPA is to further the interests of the children, not their putative parents. So it's totally flipped. The UPA was created to promote children and illegitimate children and findings of parentage for them versus what it does or how it affects the parent. It used to be that it was solely or primarily parentage was to be determined to make so the court can make child support orders. But under the UPA, it recognizes there are many other reasons that are geared towards protecting the child over those of.
What about the 2021 case of Austin versus Lopez, I believe it was?
Yeah, that case, Your Honor, is a wrongful death case. And wrongful death case really, and I've dealt with this in my practice, the wrongful death statutes are really their own animal, because the standing that you have to bring a wrongful death case are given to 3 people by statute: children, parents, and parents, and spouses. And those are the only people. And so oftentimes there has to be a standing hearing to determine whether the person that's asserting the wrongful death claim has the standing under the statute to bring it. And so that's what that case was. And the Membrano Lopez case said that she really didn't need to bring an inheritance claim under the estates code, and didn't need to bring a parentage claim under the family code, because we're in the wrongful death statute. And it also went on to say, and this is something that's never brought up, it went on to say that it was proven, parentage was proven, and in that case, and standing was determined to, the mother of the child was determined to have standing to bring the claim for the child. So notwithstanding that she didn't have to bring the inheritance and she didn't have to bring parentage case under the family code, she did it anyway. But the point is that the wrongful death cases are just totally different, and they're outside the realm of inheritance and parentage because it has its own statute and its own animal. But the thing about that case is there's one footnote that is raised 3 times in the appellee's briefs, and it sort of says, as an aside, we don't see where the Parentage Act really allows for post-death parentage findings. But the point is that was dicta. It was not the point of the case. The case was about standing in a wrongful death case, not under the Parentage Act. And then I wanted to address, so that the Schaefer case is inapplicable because it applied the wrong law. The Schaefer 2 case that came out said, you apply the wrong law, you need to apply pre-UPA law to this case. And so it doesn't apply at all. And then the George case, one of the things I want to point out in that case is no personal representative was served in the George case. They talked about the brother being, one of the parties said the brother was the administrator. The court said at the end of the case, well, there's no proof that anybody was ever appointed as the administrator. The putative surviving spouse said, well, she's the executor. There's no proof that she was ever appointed, and neither, even if they were appointed, were served. And so that really makes George inapplicable too, because based upon our interpretation of the statute, if the personal representative of the estate would need to be served in the place of or instead of the deceased parent or the deceased father. And so without serving the executor, we think that the George case doesn't apply because in this case they were served. And then the Manuel v. Spector case, the ASL case, the ASL case says Manuel court agreed with the trend in modern law to accord children born out of wedlock the same legal status as other children. And then it says, and this is at page 817 of the ASL case, legislature recognized and implemented the trend in Texas to deprive an illegitimate child of the opportunity to establish his or her parentage to be contradictory to that purpose. And it found, like Manuel, that a parentage case can be filed after the death of the father. Granted, those are pre-UPA cases, but these are later than George, and the ASL case applied or considered both George and the Manuel case and found that Manuel was better reasoned, and we think it falls right in line with the UPA. And so I see my time is running out, but I wanted to just say that there are many reasons why Justin wants to be determined to be the parent, to have his parent determine born errands beyond trying to create some relationship with his estate or the executor. He's entitled to have it done under the Constitution and to receive all the benefits based upon the equal protection of the Constitution and the UPA. Thank you.
Thank you, Council. Council, you may proceed when ready.
Thank you. I'd like to take on directly the assertion that appellant is relying on old law. The statutes at issue 160.603 and 160.604A were enacted in 2001. The legislative history providing for that enactment is in the briefing. The 3 cases that we rely upon and ask the court to really consider are Frazier, that the Houston Court of Appeals decided in 2012 after the enactment of the statutes at issue, Schaefer, which was 2009, and then Membrana Lopez, which was 2021. So all 3 of those consider the exact statutes, the exact language that is currently enacted by the Texas legislature. So it's just not true that we're asking the court to rely upon old law. while I also disagree with some factual allegations made, the key is jurisdiction is the issue here. And it's always the first question in any case. And the court just didn't have jurisdiction to enter the judgment at issue. There's nothing in chapter 160 that negates the plain language of 160.603 and the plain language of 160.604A. There are a few, I really want to point out, there's no survival provision. The Texas legislature knows to make clear when its intent is for a cause of action to survive. And we've used the wrongful death suit as an example of that. Texas Civil Practice and Remedies Code, section 71.021 is explicit. A personal injury action survives to and in favor of the heir's legal representative and estate of the injured person. The action survives against the liable person and the person's legal representatives. Chapter 160 has no such language, none. The best that DART points to is the venue provision of 160.605 and 160.610 regarding joinder. And I think it's really important that there is a way for all of those to be read such that they all make sense together. And that's it only if the putative father is alive, he's a necessary party to the action, the court has personal jurisdiction over him, personal jurisdiction attaches, and then before the court issues its adjudication, he is deceased, and then the case can be joined with a probate. And the language there is really clear on that. I think it's critical. Other cases from other states relied upon by DART that analyze other issues. The venue provision says that adjudication of parentage can be commenced in the county where the probate is pending. That's not what the Texas legislature says. The Texas legislature in 605 says venue is in, not can be commenced in, is in, suggesting that once the father is joined and he's a necessary party and he's alive, but passes, it can be joined after that fact. But critically, the court must have personal jurisdiction to issue the adjudication at issue. There were a few instances here where he harped on the benefits of fallen officers' kids. Those in Texas are specifically related to one of the ways you have to show to get those benefits is if you were filed as a dependent on the tax return. And that's because those benefits are from Texas taxpayers. And Justin Dart is a Californian trying to use this court system to enable potentially the ability to gain some financial benefit out of a genuinely tragic situation. And so to the extent that there is a fairness argument, that fairness is really to Katrina Ahrens and the minor children of Lauren Ahrens and Katrina Ahrens. I think the court issued, this isn't a constitutional issue. The statutes 160.603, 160.604A are plain on their face. There's been no constitutional allegation of that they're not, or that they're ambiguous. I just asked the court, appellate Katrina Ahrens, as independent executor of the state of Lauren Ahrens, deceased, asked the court to vacate the judgment because a lawsuit to adjudicate paternity cannot be brought after the death of the punitive father. Ask you to interpret the plain language of the statutes at issue, follow the canons of construction, and find that the trial court didn't have personal jurisdiction over someone who died 4 years before this lawsuit was brought. Thank you.
Thank you, counsel. This case is submitted to the extent that either of y'all cited authorities that is not identified already in your brief. We need that in a letter by Friday. And other than that, we'll decide the case and you'll see an opinion.
Thank you, Your
Thank
Honor.
you, Your Honor.
Thank you.
Your Honors.